I make a motion that we return to open session and report that only appropriate closed session items were discussed during closed session.
Second. A
Second.
roll call vote. Valerie?
Aye.
Joan?
Aye.
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 Okay, we are now back in open session. We're going to pick up right where we left off. Item 9B is the CPOA draft policy and procedure. This is an effort to realign our policies and procedures with the new ordinance, the new amended ordinance that has been passed. And so, Member Van Deventer, I will let you take this one.
Okay, so if you look in your packet, you have this thick red-lined document. This document was created by our council, not by myself nor Chantal. And this, what our council has done within this document is propose changes to our rules and procedures so that our rules and procedures reflect what is contained within the new ordinance. So if you just like at a glance, I think you can tell that largely it's changing the POB to the board. There are some other changes that are a little bit more substantive. Largely those changes are just additions of language that are direct quotes from the new ordinance imported into our policies and procedures where appropriate. So despite my better judgment, I volunteered to have a meeting, a policy subcommittee meeting, where we would review these changes and invite the stakeholders so that we could, so that hopefully we would be able to propose something to this board in an efficient manner instead of having to have a really, really, really long discussion, which is what we've done historically. So we went ahead and did that. We had a discussion about this document, the long one, at our regularly held policy and procedure subcommittee that occurred on June 6th. Numerous stakeholders attended. The board was informed of the meeting also. And we went through all of these. So Dr. Cass was not in attendance, but Chantal and I were able to hold the meeting because we had a quorum of our subcommittee. And what I did, what I thought was a good idea anyways, was to just pull out those changes that we didn't recommend so that we could discuss them individually so that we might obviate a need to go through this 21-page document line by line. And so what our subcommittee recommends is that we basically accept all of the changes in this red line document, aside from the ones that I have pulled out for discussion by the board. So the ones we pulled out for discussion by the board were we basically just ran through and attempted to identify all the stuff we thought the board would care about and want to talk about. So if you look at this document I created, the Word document, the first thing we pull out is page 4. Page 4 where our attorney recommends the deletion of the case review subcommittee. We pulled that out because we thought that was appropriate for a board discussion, which we have essentially already had. So I think we can kind of move on and not even discuss that, but that would be the first example. Then on page 7 of this document, we have a suggestion that actually came from City Legal, from Steve Aguilar, and he wanted the city attorney, City Legal, to be included in the list of people to whom we send our annual performance evaluation of the executive director. I consulted with Tina at the meeting, and she said that is not required by the ordinance, but it would tend to make sense. So I pulled this out.
7. We're on 7.
Page 7D.
These don't actually have page numbers.
D. Oh, I put
Yeah.
page numbers in mine. Okay.
That's a good point. My recommendation, which you'll also see on this document, is that page numbers be included for ease of reference.
So where is it?
So let's all find that. 1, 2,
It's
easier with electronic.
Why,
So
why do
7D?
you think that the city attorney having access to this is a good idea?
I don't have a position on it. It was just something that Steve recommended, and then Tina thought it was a good idea, and I thought was appropriate for discussion. So Tina, could you let us know why, remind me why you thought that was a good idea?
Chair Galloway and Member Van Deventer. The more involvement that the lawyers have knowing what is being transmitted to their client, the better in this instance. It will help keep the lines of communication open. The ordinance lists that the chief of police, the mayor, and president of city council are to receive this summary of the annual performance review. I don't know why Mr. Aguilar proposed it, but from my perspective, I would like to be able to have the folks that come to your meetings know when these things are transmitted, so that when you ask them questions in their presentations, they are aware of when it was sent, so that they can answer when it's going to be received by city council, or if the mayor has a question about it, so that there is not a breakdown in communication about the board complying with its functions, or at least an allegation that there has been a breakdown in communication. It is a document that the board has to provide to the folks listed. It is not required to be provided to the city attorney. It eventually will get to him or her in that role if their clients are passing on the information. So adding them to the list of who the administrative office knows to send it to doesn't pose a particular concern from my perspective.
We had this discussion when we talked about this in the ordinance. And the idea was that, you know, any personnel file shouldn't be shared outside of where it needs to go. And when, obviously, we had some discussion even about the chief of police. We talked about the president of the city council, since that's the establishing body that creates this body. We need to for sure tell them, but we had questions about whether the mayor should get it. We had questions about whether the chief should get it. So I'm not okay with adding people to that list. If they're, if he's, you know, those people are his clients, good for them. They can tell him. But I don't think, if it were me in that position, I wouldn't want my evaluation going everywhere in the city. And that, to me, is everywhere.
So the thing that's missing from this document that's in this one, and that is part of the ordinance, is it's not the evaluation that's going, it's a summary of the evaluation that is going to these individuals.
Okay.
And I think that Ms. Gooch is correct in saying they're gonna get it anyway. We can
Yeah.
hold,
That doesn't
you know,
mean, that,
pin
so
it.
that doesn't mean that we should send it to the union head either.
If they're not part of the,
Well, I mean, they
Part of the
could
ordinance.
send it, I'm just saying, do we not have an obligation to be circumspect about where this information goes?
I think that it's reasonable to expect that it would go to the attorneys for these, for the city. I don't think it's reasonable to expect that the APOA would have a right to it. And so I think that to group those two together is doing each other a disservice. But I don't particularly have an issue with it. It's not the evaluation itself, it's a summary. They're likely going to get it anyway, and there's no reason for us to expect any kind of contention.
Yeah, I don't know. I felt like Tina thought it was smart, and Director Harness didn't seem to have an issue with it. I don't.
Is that true, Mr. Harness?
Chair Galloway, Vice Chair Fine, that's correct.
Okay,
It's a summary of,
it's good enough
it's
for
a
me.
summary of of the evaluation, and with all the parties that are already named in the ordinance, I think the city attorney is appropriate as well.
Okay, I'm done.
Okay. So can we just have a motion then to include the city legal on page 7, item D? That's my motion.
Can we say to accept and then do one to accept all the changes at the end?
Well, we're gonna have to come back to this page 4 thing,
Okay.
so.
All right, then a motion to include city legal in the list of recipients of the summary of the executive director's evaluation.
The city attorney.
That's the
is what
motion.
you mean?
Yeah.
Yeah.
City-
Is there a
what did I
second?
say?
Yeah, second.
All in favor?
Aye.
Aye. Any opposed? Okay.
Okay, so the next thing that popped up for us was page 8. So if you take a look at the next page, item B. Oh shoot, did I get the page wrong? I'm sorry if I did. It's so hard without there actually being page numbers to get this right.
I have numbers on mine. Which is it about?
It's
B and C.
This isn't, yeah, do you know what page this is? This 9?
Sorry.
Chair Galloway and
Yeah.
Member Van Deventer.
This one.
Before we
Okay.
move from the last vote, can I get clarification if it's going to say the city attorney will be provided the summary, or city legal? It was unclear on the vote.
City attorney, right, would be better?
Okay, thank you.
Okay. Okay, sorry, guys. So on page 9, if you look at item B at the bottom B, in red where there's a change, this suggestion came from board member Chantal because this language is essentially confusing because it reads as is, neither the board nor any of its members shall file or initiate a complaint on behalf of a member of the public. But then it says, any board member who files or otherwise initiates a complaint shall recuse from taking action on the complaint, including evaluating the complaint and voting on its disposition.
So you can't do it, but if you do.
Right. And so,
Well, that was what we thought it was saying, but I don't actually think that's what it was intended to communicate.
yeah, and so this is it is verbatim from the ordinance. However, our attorney, explained that just because it's in the ordinance verbatim doesn't mean that we can't break it up for clarity. And so if we simply do an item B, neither the board nor any of its members, and then an item C, any board member who files, then those two statements no longer contradict each other because they're about different things. And the order of the language is exactly the same still as it appears in the ordinance. So that seems like a really non-problematic way to handle it. And so that was and then we would relist the rest of the items alphabetically since we added a new break. And so that was the recommendation we had for dealing with this.
Okay, so if it says, the board or any of its members shall not file or initiate a complaint on behalf of a member of the public, full stop. Any board member who files or otherwise initiates a complaint, meaning not from a member of the public, is that what you mean?
Yeah.
Of their own. If I were to file a complaint.
I can't vote on it.
Right, if I were to file a complaint, I can't vote on my own case.
Okay, it still sounds like it's in conflict. So, board members who file complaints otherwise, I mean, you see what I'm saying?
Yeah,
It
it's-
sounds like, I understand breaking it up makes it a little more separate, but it still sounds to me the way it's written.
It was the most elegant solution we could come up with.
Okay.
So if you have a better one, I think we're all
What about,
ears, but it's hard because this
Any
is
board
exactly
member
in the
who files
ordinance.
or otherwise initiates a legitimate complaint. In other words, you're referencing that the one before is not a legitimate complaint.
Well, I think that, okay.
No, they're just two separate ideas. And so having them coupled here is what is problematic.
Okay.
So the first idea, I think, and kind of we all came to agreeance on, is that if Mr. Olivas out there were to come up to me as a general member of the public and say, hey, I've got this, or if I, as somebody who wasn't a part of whatever situation he had going on, decided I was going to take umbrance with it and file a complaint, even though he's not filing a complaint and I have nothing to do with it. That's the first one, filing a complaint on somebody else's behalf, versus if I have an issue with APD and I file a complaint about my issue with APD, that's the second one. Does that make sense?
Yeah, and I think that is the first one take care of, for example, we've had cases where Leonard has recused himself. I recused myself on one because I knew the people in the complaint. I didn't file the complaint, but I recused myself from voting. Is that,
I think that's separate.
That comes up later.
Okay.
Because there's rules about recusal
Okay.
later on. So,
This just takes care of,
Okay.
we're not gonna, just because we sit in this and we live in this world all the time, we're not just gonna go out and make complaints on behalf of other people.
We're not looking for clients.
Exactly, exactly, versus our own issues. And
Okay.
so if we separate those two out, it maintains the language that's already in the amended ordinance and offers that clarity.
Okay.
okay, so I guess I'll make a motion that we accept this recommendation to break these two items out for clarity.
I'll second it. All in favor?
Aye.
Aye. Any opposed? Okay.
Okay, now we get to the part that Board Member Fine was, I guess, just raising. There, on pages 14 and again on page 17,
What
we
is the
see
part,
some,
excuse me just a second, on page 9, it says relist subsequent items alphabetically.
Everything else
Oh,
that
it
comes
just
after.
changed these. Okay, I'm with you. Sorry.
oh, it's okay. So, basically the ordinance, institutes some new code of conduct stuff for us, which is like refrain from ex parte communication, it says. And if there is it says that like subsequently, if there is improper ex parte communication, recuse. It says something also about like recusal when there is a conflict of interest, which could happen because, for different reasons, because you know someone or, you know, you have whatever reason
Yeah.
that prohibits you from treating a case impartially. And so that stuff we sort of like just accepted all the language that was in the ordinance because there isn't much of a choice around that. But I did think that we should get some information from our attorney as to how to interpret what improper means as far as ex parte communication, because I brought up the example where an attorney who I knew contacted me because he hadn't heard about a complaint, and then I said, contact the CPOA, and I was making the argument that I don't think that that is improper. And then as opposed to like we have this case 132 and we've had a lot of communications from the complainant, and then there are concerns that that was improper. So how do we know what's proper and improper? And so I asked counsel to give us some to write definitions for us of improper and conflict of interest, and those are right below. So she provides.
Page 14, you're on?
She provides, well, I'm on my document.
Okay.
So this is what she proposes we incorporate into our rules and procedures to define ex parte. So for the purposes of these policies and procedures, ex parte communication is defined as a substantive communication, whether written or oral, outside of the public meeting process, outlined herein between a member or members of the board and any member of the public regarding the merits of a civilian complaint or the proposed findings and recommendations under review by the board. Communications between a member or members of the board and the staff or attorneys of the CPOA shall not be considered ex parte communications, provided that such communications are not relied upon to make factual determinations by a member or members of the board. So that would mean basically that you could still go to a picnic with a third-party complainant, but you can't talk about the complaint. And so that's the definition she proposes putting in here. I think it would be smart to have for posterity, which was why I asked for something, but you guys might disagree, but that's what she wrote.
I don't disagree.
I don't disagree. I think it's a good idea.
Okay,
you did it in 2 sentences too.
okay. And then the,
Director Harn?
Chair Galloway, who's going to define substantive communication?
Tina?
Chair Galloway, the dictionary, I guess. It is hard to put together a all-encompassing definition for something as complex as the idea of an ex parte communication. We've utilized the City Council's zoning and hearing examiner rules of procedure as a template for guidance for this board as to what their ex parte communication definition includes. It's been tailored based on the CPOA, and if the board has a question of an agency investigator or staff member, or me for that matter, so that it's encompassed. As far as substantive, that is a question that the Code of Ethics should help guide board members on. It is a moving target in the legal community. It's a moving target in the judicial community. It is a moving target. To provide an all-encompassing definition of substantive, I'm not sure that I can do that. I can endeavor to do that if that's something the board would like.
Can we just go off of what feels like or seems like is very typical, a reasonable interpretation of the word, and if it's ever in question, bring it up to the board and decide whether or not somebody should recuse themselves or...
So, well, one other thing that I think is worth noting here is that another part of the ordinance requires that if there is an ex parte communication, that has to be reported to the executive director and even APD. That's in the ordinance. So, I mean, I don't feel like we really need to do a ton of policing around the word substantive, because any communication whatsoever has to be reported. And so, there isn't, I mean,
Is that
there's
what a
not
court
a lot of...
does? Is that what a court would do if someone was accused of having substantive ex parte communications with somebody? The court would sort out whether or not whatever the communication was substantive? Do we have to define it now? Wouldn't it be defined in a adversarial court situation?
Chair Galloway, board member, Vice Chair Fine. That would be something that the court would have to figure out, and it's usually a reasonable person standard that you look to your policies and procedures, you look to other related, although not entirely binding ways that, the judiciary does things, lawyers do things for guidance. I would be happy to either one, delete the word substantive, or two, try to find a definition, maybe from Black's Law Dictionary, if that would lend guidance to the
Can we
board.
back up just a second? I thought that there was something, I thought that in what you just described before, that any communication about a case would be not kosher, just by itself. So if you're not talking about a case with somebody, what are you going to be talking to them about that is substantive and in violation?
Can we go back to the same example that came up in our meeting? That we had the two different cases. We had 132, and then we had the email communication with Member Van Deventer and the attorney, where that communication was simply directing that individual back to the agency. That was the extent. I saw it. That was the extent of that communication. I would not say that's substantive communication about a case. That is appropriate and actually follows.
It's a redirect, it's not
it follows
information,
the
it's not
CASA.
opinion, it's not
But
promises.
I believe that executive director has an issue with that, in that there was an ex parte communication that occurred, period, right? Like, just that there was something that occurred was an issue.
Chair Galloway, I'm not sure that properly states what my objections were. My objection wasn't necessarily the communication. My objection was what I believe to be the influence. But back to my question, I think if you're adopting the paragraph and you simply remove substantive and you say communication, it guides you to say, regarding the merits of a civilian complaint or proposed findings and recommendations under review for the board. So that's the communication
Except
that would
then-
be prescribed as ex parte and therefore grounds for recusal.
But, okay, but then when you delete the word substantive, the effect then is that when I told that attorney, hey, why don't you try calling the CPOA, that communication is prohibited. And that's exactly why, because it just turns it into any and all communication, which was exactly why we were asking, why I asked our attorney to suss this language out so that we could have more guidance.
And the flip side to that is we're required by the CASA to give that information, who the appropriate contact is if we are approached.
Chair Galloway and Member Vandeventer, it specifically says, between a member or members of the board or any member of the public regarding the merits of a civilian complaint. Simply telling the CPO to call the CPOA is not the
Discussing
merits of the case, or
case.
discussing the merits of the
Okay,
case.
I could buy
Okay, I'm
that.
good
Yeah,
with
Or
buy
the
that.
proposed,
I
or
buy
the
that.
proposed findings and recommendations under review.
Okay.
Okay.
Point well taken. So we're suggesting that we cut out substantive.
Yeah, so let's sort of like adopt that a little and then get through the conflict of interest, the next piece, before we just vote on both
Okay.
sets of language. Is that okay?
You got it.
Okay, so then I asked our attorney also to define conflict of interest also for posterity. I mean, I think most people have like a lay definition, but just, you know, to have it in there for all future board members. And what she wrote was, a board member shall withdraw from any proceeding in which he or she has a direct or indirect conflict of interest. For purposes of these policies and procedures, conflict of interest shall include any proceeding or official act in which the board member has a direct personal financial interest, any proceeding or official act affecting a business in which the board member has a financial interest, and any proceeding or official act in which he or she does not believe he or she can provide a fair and impartial hearing because of personal opinions or biases that would prevent the board member from acting fairly and impartially. Board members should err on the side of caution and withdraw from any proceeding in which there is an appearance of a conflict of interest. So that's what she proposes.
I don't have any problem with that.
Me either.
So then I would, if you guys like these two additions of definitions to our rules and procedures, I would move that we incorporate them, striking the word substantive as discussed, into our rules and procedures.
And you moving that, Leonard just seconded.
Motion second.
All in favor?
Aye.
Any opposed? All right, motion carries.
Okay, so now if you turn to the subpoena, page 13, I believe is where it starts.
13?
Yeah, well, so the actual subpoena itself is at the very end because Tina made a form subpoena for us to review. But the language about subpoenas for our rules starts on page 13. And we had a discussion of this. We thought that Tina did a good job and we're prepared to recommend. The city attorney, Steve Aguilar, identified one minor correction. And I just couldn't, my notes about that like fine point were not the greatest, so I need you to remind as to what it was, unfortunately, but.
Let me see.
Chair Galloway and Member Vandeventer, in the form subpoena at the very, very, very back of the packet, it's a bunch of red, and it says Appendix A. The page number, which is odd that now there's a page number, I don't know why RTF files do that, but page 24, that has a page number on it, includes information for the person that receives an administrative subpoena, and it's under protection of persons subject to administrative subpoenas, and it is the third paragraph under that title. It starts, a person commanded to produce and permit inspection, and copying may, within 14 days after service of the administrative subpoena, serve upon the agency designated, as well as the city attorney and civilian police oversight agency board objections, or within 14 days, go to a district court to seek enforcement or non-enforcement of that administrative subpoena. What our city attorney pointed out is that while we have encapsulated that 14 days in the actual subpoena, it doesn't also show up as clearly in the policies and procedures. And what his recommendation was to include where we talk about when an administrative subpoena is issued. It's on page 14, section F. Parallel language from the actual subpoena that's going to be sent, so that when the board or the agency is trying to go through this process, it's real clear. Right now, it just says that the administrative subpoena must provide at least 14 days notice, but it doesn't talk about if you want to fight it with the court system or if anyone else wants to lodge an objection. So his recommendation was to take the paragraph from the form and make sure it also is in the policies and procedures. And that was an oversight on my part.
I felt fine with doing that, so.
So we recommend making that change. I make a motion that we make that change.
Second.
Tina, all in favor?
Aye.
Any opposed? Great.
Okay, so I got an email after the meeting which just identified like some typos and stuff. Mostly it was typos. In one place it was the wrong word. It was accept instead of expect, or the vice versa. And then there was one area where the word choice was like out of order. And since there were just like a lot of independent minor instances of this, I thought that it would be okay to make the general recommendation that would allow our council to correct typos and errors when finalizing this. And so I don't know if anyone has a problem with that. Okay, so my motion would be to allow our council in finalizing this document to correct identified errors, typos, misspellings.
Second. All in favor?
Aye.
Any opposed?
I didn't think you guys would want to go through those one by one either, so I just did a lumped up. Okay. Then there was this recommendation. This came from the CPOA at the meeting. And this is in reference to that edict that came down after the city council forum was held. And so this is just language that says, pursuant to this new ordinance that was, that related to that we can't do that. And since it's a rule that applies to us, I think it's a good idea to have it in the policies and procedures. That way a future board is informed of that without needing a separate learning experience,
Yeah.
So I move that we accept that recommendation from the CPOA.
Okay, I second.
All in favor?
Aye.
Any opposed? Great.
Okay, so then this is the last one, and this is really kind of like the only oddball because it's not really related to the ordinance changes, but Chantal had it, and so I included it here for discussion. And it's adding a section requiring the board to vote on a recommendation to city council regarding the reappointment of an existing member to an additional term. Meaning we're giving the city council like a nod and a wink, I guess, if we want to reappoint, and then we're sending them a red flag if we don't want the person reappointed. So we would take a vote and then we would send a letter. And so there isn't language here, that's just like the idea that Chantal is proposing putting into the ordinance.
So sort of.
In the ordinance or the
No,
policies?
in the policies and procedures. So that's sort of, that's one way to characterize
Did
it.
I get it
More what it's about is just that we have a hand in our own destiny. We're taking the opportunity, and we've been provided the opportunity from city council to kind of onboard new board members, have a hand in that. There's open dialogue and discussion about how potential board members are vetted and chosen and all of that good stuff. This is the logical next step. And we did this when Valerie and I were reappointed, and we took an affirmative position. It's kind of also in line with taking affirmative positions on policies and whether or not we think that recommendations should be made, or we're fine with things as they are. It's just bringing our voice to the table more than anything.
May I speak?
Of course.
I understand where you're coming from, but I am not in favor of this. I
Okay.
think we need to leave it as is, because the city council is still working on their part, how they're going to do this. And I think it needs to kind of be resolved at their end, but I think it's their business and it's not ours.
I'm confused as to what.
As
What are
to-
they working
well-
on?
Well, no, they're working on I've been heard, they're working on the policy for new board members, who's going to interview them, who's doing this, but I think we still need to leave it to the city council. This is their decision. I'm just not in favor of
Okay.
this.
It's not new board members, but okay.
Okay.
So,
Anything else?
I mean, for the board members that are the current existing board members.
So maybe it's a process by which, I mean, if I was on the city council, one would hope that, as new board members are about to roll off, board members are about to roll off or meet renewal, another thing you could do is not make a recommendation, but remind the city council, write a letter to the president of the city council saying, 2 months ahead of time, we're gonna be in this place, either renewal or finding new board members, so that we give plenty of time for that. And if I were them, I would appreciate that.
And that was Tina's kind of bolstering point in our discussion, is it would be the heads up so that nobody's surprised.
Yeah, because we buy our own time with that. We hamstring ourselves without that. So maybe it's 5 months out and not 2. We say, it's the board's responsibility to notify, so Leonard, when is our letter due?
Yeah. Well, this says something completely opposite of what you're just saying. What it says is that the board to vote on a recommendation for the city regarding.
I know,
Okay,
I'm
so-
purposely saying something different.
Right, yeah, I know, and I understand what you're saying, but it's not what this says, so I'm gonna vote
Yeah,
against
and
that.
she's saying this is just the idea, throwing it
Yeah,
out there.
this is just the discussion. If
Yeah.
we settle on something we want to put in there, I think
Yeah.
we
We
can
can
make
rewrite
that
that.
recommendation.
I understand making notification or letting them know that, we're getting ready to lose a couple people or
Well, and especially,
whatever.
that might be good also in terms of the academy, for example. We're going to have new board members at some point, or we're going to have people that need training, whatever. It's just on us to make sure that information's always out there, but recommending
Yeah, recommendation.
board members is not, I agree with Valerie, is not our business.
Okay, so do we want to adopt language that says we will notify city council? What would be appropriate? My gut is saying 6 months, but
Let's
Ooh,
do
that's
this.
too
Why don't
far.
why don't we vote on this one and then
Yeah, let's vote
We
this
can.
vote it?
Okay,
yea-
okay.
yea
that
or
works
nay,
too.
Or,
Yeah, we
Someone
can do
make a
that.
motion on this recommendation then, please.
I move that we don't accept this recommendation.
Okay, I'll second your motion.
Okay, all in
This
favor?
recommendations.
Great. Any opposed?
So this will be struck from whatever it is this final package looks like. Okay. Now, what is the recommendation?
Go ahead.
The recommendation is that 6 months prior to a board term expiring or being up for renewal, we notify the council that those changes are about to happen or action is required on their part.
How about 3 months? For me, 6 months is so far away
but
that
it's
I'm
the
I'm
city
just gonna
council.
forget about it.
But this is the
It's
city
even worse.
council.
And
It's worse for them.
the flip side to the city council, is that means that that's 12 meetings in advance. I think that there's a good point to that, where ours is 6,
They're so
would be
slow that,
6.
because they have so many balls in the air. I just think it's important for us to do that and put it on their radar with enough time to them to actually get something done. Look how long we waited now.
Yeah, this was a special circumstance, though, I think.
Let's make sure there's no more of this special service.
6 months prior to, you want to go with
Yeah.
that?
That's fine.
Okay.
Would you-
So
maybe
6
we should-
months prior to board
Valerie has
member,
Excuse me, maybe 6 months, and then I would probably do them a follow-up and give them like another 3 months.
Well,
We
we
can
can
do
put it
that
on the agenda.
informally.
for
Okay.
You
June.
can do that,
Yeah.
yeah, because it's going to get lost.
So,
We can put it on, as soon as we send them the letter, we can put it on. the
Put it on the
agenda for
agenda.
June.
would you guys be okay with, as a part of Joanne's motion, that we just approve this general concept and our attorney can finalize the
Sure.
language?
Yeah,
Okay,
that's
that just
fair.
makes it easier. Okay, so,
So 6
I
months.
second your motion, Joanne.
all in favor?
Aye.
Aye. Any opposed? Great.
May I ask for clarification?
Yes.
Chair Galloway? In that language, would the board like to include language regarding if a board member is not eligible for reappointment, if they are eligible, if they would like to be reappointed, or would you just like a more general language of a transmission
Yeah, I
to city
think
council?
I think it's their, I agree with them. It's their decision to make. And, we appreciate the service and they are interested in continuing, so they know. And that we're expecting to hear back from you.
So I don't know that that really answers your question. I think that what Joanne is saying is that go on ahead and include something in there that lets them know that the board member themselves are interested in being reappointed to the board.
Or they can't be
Or
because they're timed
ineligible,
out.
yes.
Ineligible, right.
Okay, thank you.
Okay, so then the last thing, although I don't know, yeah, I guess we should go ahead and do this now, even though we're not gonna adopt these like full on, but the ordinance now says that the board shall submit rules and regulations governing civilian complaint procedures to the city council for approval, including rules and regulations relative to time limits, notice, and other measures to ensure partial review of civilian complaints against members of the police department. And so our attorney is wanting to know if, okay, let's say, though we haven't done this yet, but let's say hypothetically, we approve all the stuff that the Policy and Procedure Subcommittee is recommending at this time, but for the CRC stuff, which I guess we'll have to pend, are we understanding this to mean that we have our attorney finalize this document, but for the one item, and then send it to City Council for approval?
That's what we had to do the first time.
Yeah.
We had to submit
I think that's what
the
it means
rules and
personally,
policies and
that we should do
procedures
it.
and say, these are the rules we're going to operate by, and the council had to vote on it.
Yeah, I think we should do that too.
It's just it's a notification of what, the rules. If they have objections, they can tell us what they are. But I know we did it the first time.
Why do we think that it's this and not just around civilian complaints? I'm sure there's a reason for that, but
I'm sorry, what?
I'm
Well,
assuming
this-
you're talking about this piece right here. Your-
Well, just like this document as a whole contains a lot of things included in this list,
Yeah, why
like
don't we just take out
rules and
civil-
regulations governing civilian complaint procedures, like those appear peppered throughout this, so.
Well, why wouldn't we just say instead, the board shall submit rules and regulation governing
this is what
This
the
is the
civilian
ordinance.
police oversight agency and its board?
This is the ordinance. We can't change this.
Yeah, the question is just, does this language right here from the ordinance mean that we have to give them this to vote on or not? What are we gonna do? Are we gonna give it?
We had to give it to them the first time.
I agree with you, that's what I think we should do, but.
They
I'm
have to
okay.
approve it.
I'm okay with doing that, but that's not what this says. This says civilian complaint procedures. I get what you're saying, but there's a whole bunch of other just like general business stuff in here that is ours, that we own, that's completely separate
Oh,
from
I see
that.
what you're saying.
And so I don't think that they need to approve all that. If you guys want to give them all this, I have no issues
Well,
with
there
that
is
either.
a document that we developed together initially that was called Policy and Procedures, the rules governing this board and agency.
This is that document.
Yeah.
Policies and procedures.
And so that is what was presented to the board. So if that's not the right quote, it doesn't matter because we still have to do it.
Well, we don't have to give that. What I'm saying, I don't care, mind you, I'm not making the argument against giving them this. I'm just saying this in its entirety is separate from what the ordinance is requiring of us. Just like including city attorney's office.
Is
and
there
the-
something in the ordinance that says we're supposed to submit the policies and procedures? I understood our previous counsel to say that was true.
Chair Galloway, Vice Chair Fine. This language that Member Van Deventer has read is verbatim from the ordinance. The question is whether the board believes that this change or the rewrite or the updates to the policies and procedures are within the realm of the amended ordinance or not. The last round of policies and procedures that were updated by the board, we did not bring to city council. Those, however, were not dealing with impartiality or how civilian complaints were being addressed. They were instead dealing with the business of the board.
So you're not aware of anything in the revised ordinance that says we can't just notify them and say, here's our new policies and procedures to be brought in line with the amended ordinance?
Chair Galloway, Vice Chair Fine. No, this is what the amended ordinance says. This is the only language that
Okay,
contemplates
then they don't need a vote.
communications.
If it doesn't say in the ordinance that we have to submit it for a vote, we can just give them an FYI, here it is.
Chair,
Amended.
Chair Galloway, Vice Chair Fine. I read this as saying that the board shall submit rules to city council for approval. But the question I have for the board's consideration is whether the board believes that what this rewrite includes are the delineated items that require that submission to the city council. And those are rules and regulations related to time limits, notice and other measures to ensure impartial review of civilian complaints against members of the police department, versus if the board wants to decide that it's going to elect a chair of a subcommittee in the March of every year, which is not within the realm of the ordinance provisions.
Okay, what do you think it should say then? Which way should we go? don't
It's
get
just
it.
a matter of how we're going to, do we want to present this document as a whole? Or do we want to present the civilian complaint procedures? I'm sorry I brought this up, because I don't care that that we want to submit this.
there's nothing
I'm
in
just
the-
saying the reading of it is different.
Is it not true, or is it true that this paragraph quoted from the ordinance requires us to submit our policies and procedures as they exist to them for approval?
Chair Galloway, Vice Chair Fine. No, not broadly. But if to the extent we are changing the policies and procedures regarding impartial review of civilian complaints or relative to time limits, the answer is yes.
I'm so sorry. I'm going to make a motion. We can keep discussing if we want. I'm going to move that we send them this whole document.
Okay, great. I will send
Whether
you
it's a
that.
courtesy or not, I
Yes.
just think it's a courtesy.
Yes.
And, you know, if they have issues about some of the delineated stuff, they can communicate that, and
Yeah.
then we can go from there.
All in favor?
We're not asking for approval, we're just sending it to them as an FYI, right?
Well, I
That's
think
what-
we're
that's the
asking you
question.
to approve.
I think that if you send it as a whole, and I'm not opposed to communication, if you send it as a whole, you're opening it up for feedback in areas that
Not
does
if we just say
not,
FYI.
that does not concern, you're giving it to them, so they have the opportunity to respond. We've given them that step. I don't care, I'm okay with talking about
Then
it.
let's not do it.
So all in favor of sending this as a whole? We've got a motion and a second.
No.
Okay. Oh, I haven't gotten there yet. So all in favor? Aye.
I,
No.
Okay, any opposed? Joanne is opposed. Okay.
okay, now hold on one second, because there needs to be a little bit more clarity here regarding, okay. So I just want to make sure that I understand from all of you that the broad recommendations that the Policy and Procedure Subcommittee made, which is basically like anything we didn't bring to you on here that's in here, that's okay. Are you guys okay with that?
This is
We
the
should-
stuff we already went over
We,
line by line.
we should tell them what they
No.
are.
Well, it's the stuff, no, because that's
Well,
what
just
we're
like
trying to
generally
avoid.
speaking,
Well,
like
yeah, generally
board
speaking.
to, police oversight board to, board for the civilian police. It's that kind of stuff.
Yeah, so what the instances of POB becoming the board, and instances of incorporation of the language from the ordinance directly verbatim into this document where appropriate.
Yes.
Is largely what we are recommending wholesale, so that we don't have to do a line-by-line review.
Exactly.
Are you guys okay with that?
Are you?
Yeah?
Yeah?
Okay.
Because the next option is, let's set a special meeting and go over this line by line.
No,
Okay.
we don't need to.
Okay, fantastic. Okay, so then, Leonard, yes.
I was just gonna make a motion that we approve those changes
Second.
as
Okay.
presented.
Okay,
All in
And that
favor?
covers
Aye.
the-
Aye.
okay, and now the last final thing
This
is
one?
just, so the pull-out ones, we've done all of these, okay? And then the broad ones, we've just acted upon.
Right.
But we have no decision on this page 4 item, because that's the case review subcommittee. So would you guys like to, I can see us handling this 2 ways. I can see us finalizing this document, on all of this stuff that we've discussed except for that item, and then just coming back to that at a future date.
That's fine.
Or we could just, I could just
Don't
save
send
my
them
notes
anything in the
and we just
meantime.
wait until the CRC is done.
I say do a package deal, do it all.
Okay, so I'm gonna do a package deal. Can you delegate the authority to me to finalize this with Tina? That way,
Yeah, once we reach a conclusion on
Yeah,
that.
just getting like the finished, like, because they're, like, we just agreed, for example, about finalizing this language about 6 months prior to a board term expiring, that kind of minutia. Can I have the authority
Yep.
to finalize that?
Yes.
Okay, so I will finalize all that stuff and then we will,
You gotta give her, let's make a motion to give her
Yeah.
that.
Okay, I move that we allow Chelsea to clean this
Finalize
up,
everything
finalize the,
up to, but not including the case review committee.
that's my motion.
okay.
Second.
All in favor?
Aye.
Okay, so I will make sure that I communicate with Tina and that gets done, and then we'll just send you guys notice that we've concluded this work.
Okay.
And I say don't send it to anybody in the city until it's done.
Okay.
Leonard?
Okay, so continuing, are we done with this?
Yes.
Okay. Continuing down our agenda, there are no serious use of force or officer-involved shootings. No Garrity of materials that we need to vote to see. We've done that. Any other business? Nope. Okay, our next regularly scheduled board meeting will be on July 11th at 5 PM right here in the Vincent E. Griego Chambers. Can I have a motion to adjourn?
So moved.
All in favor?
Aye.
Aye.
Thank you.